I want to discuss with you History of Indian Contract Act 1872. How actually Indian Contract Act was framed and when it was implemented in India, when it came into force, and how many sections are there in the act, and later on how actually some sections are removed from this and what happened to those sections. Now at present how many sections are there in Indian Contract Act 1872? So this is all we are going to discuss now. Let us discuss it. Actually Indian Contract Act is related to contracts and its rules, how to frame the contracts and what are the rules of those contracts. So these all are mentioned in the Indian Contract Act 1872, and this law actually came into force in India on September 1st, 1872, and it is applicable to all the states in India. It is applicable to the whole India except Jammu and Kashmir. So we can't implement this in Jammu and Kashmir, and remaining all states follows this act. And in this Indian Contract Act 1872, in total 266 sections are there, and these sections are divided into some groups. First one is General Principles of Law of Contract, and this General Principles of Law of Contract has section 1 to 75 sections. And next one is Contracts Relating to Sale of Goods, and here from section 76 to 124 are related to contracts relating to sale of goods. Section 1 to 75 are actually related to General Principles of Law of Contract, and section 76 to 124 are related to contracts relating to sale of goods. And next, third one is Special Kinds of Contracts. What are special kinds of contracts? Special kinds of contracts means, for example, it may be indemnity contract, guarantee, bailment or pledge. These all are special kinds of contracts. Rules regarding all these special types of contracts are laid down from section 125 to 238 in Indian Contract Act. Next, fourth group is contracts relating to partnership. Everyone know what is partnership business. If two or more than two persons starts any business, that is known as partnership business. Rules related to partnership are laid down from section 239 to 266. So this is the total picture of all sections in Indian Contract Act 1872 at the initial stage. Later on, they removed some sections from this. And what are removed? What groups are removed from this? Two are removed: Sale of Goods Act and in partnership rules. These two are removed from that. So contracts relating to sale of goods, that is from section 76 to 124, that is removed. And next, contracts relating to partnership, that is from section 239 to 266. These two are removed from Indian Contract Act. And remaining two, what are those remaining two? First one, General Principles of Law of Contract, that is section 1 to 75, and contracts related to special kinds of contracts, that is indemnity, guarantee, bailment, pledge, section 125 to 238. These two are there at present. And remaining two, second one and fourth one, contracts relating to sale of goods, section 76 to 124, and last fourth one, contracts relating to partnership, section 239 to 266. These two are removed from Indian Contract Act, and they made those two as separate acts in India. So these contracts related to sale of goods, actually they created it as, actually they made it as another act, that is Sale of Goods Act 1930. And next, last one, contracts relating to partnership. They removed that from Indian Contract Act section 239 to 266, and it actually rules related to partnership are made separately in another act, and Indian Partnership Act 1932 was framed. And remaining two are there in Indian Contract Act at present, and these two are divided into two parts. What are those? First part is section 1 to 75, and it is related to general principles of the law of contract, and second part is that is section 125 to 238, and this is related to special types of contracts. Okay, this is history of Indian Contract Act 1872. Hope this is clear to everyone. This is important. You should know before knowing the Indian Contract Act. You should know what is the history of this and how many sections are there, and what actually were the sections at the beginning stage, and how it was divided into. Okay, this all you should know. Hope this is clear to everyone. If you understand, like the video, share the video and subscribe the video, so that others also will understand it and it will be useful for others also. Let us go and discuss the next topic. Let us discuss what is invitation to an offer, and why we don't call that invitation to an offer as an offer. Offer means proposing something to another one. So proposing our intention to do or not to do anything is known as offer. And is offer and invitation to offer both are same or not? Let us discuss this. Actually, we should distinguish this offer from invitation to an offer, because both are not same. Both are not one and the same in the eyes of law. Both are different. Offer is not same if we compare with invitation to an offer. That is different. Invitation to an offer is different and offer is different. Both are not same. Let us discuss what are all those. Offer means we must, if we propose anything to another person to do or not to do anything, so that is known as offer. If other person accepts it, that will become an agreement. If that agreement is enforceable by law, it will become a contract. So here offer means proposing something to another party. Okay, so invitation to offer means actually circulating information about our business with any other person. So this is just invitation to an offer is just a circulation of some information regarding our business, that we are disclosing about our business, that our business is existing and it is there and we are going to sell something. Okay, so that is just an invitation. We are just circulating the information. Okay, whenever any information is circulated, that is known as invitation to an offer. That is not an offer. Okay, so such invitations are not treated as offers in the eyes of law. So what will become invitation to an offer? What are the examples of that? Displaying goods in the shop with price tags. Okay, so that is invitation to an offer. If you go to any shopping malls, anywhere else, goods are displayed with price tags. So we can't treat it as offer. That is just an invitation to an offer. And catalogs containing description of goods. If any catalog is there and some description of goods also is available in the catalog, and those are made for sale actually. Why catalogs are provided? Because that person, that seller or businessman is intended to sell those. So he is giving some invitation to everybody. So catalog containing description of goods is not an offer. It is just an invitation to offer. Okay, seller wants to invite the people to make the offer. Okay, so next, displaying goods in the shelves of the self-services shops. So if any shop is there, self-service shops are there, so in the shelves they display so many types of goods, and it is not an offer. If they display goods in the shelves, it is not constituted as an offer. it is just an invitation to offer. He is just displaying the goods so that people can see those and people can make the offer. Okay, seller, that sell service shop seller is just displaying the goods, so he is inviting people. Okay, that is just an invitation to offer. Customers makes the offer. Whenever they want to buy, they will make the offer. Hope this is clear. Invitation to an offer is different from offer. Both are not same. Okay, so let us go to discuss the other topic. What is counter offer? Counter offer means actually one person makes the offer, means he proposes for something to another party. So whenever one person makes the offer, we call him as a offerer. The party to whom he made the offer is known as offeree. So here first party is making an offer, that is known as original offer. Okay, and here the other party to whom the offer is made, what he is doing? He is making some changes to the original offer, and whenever he makes any changes, automatically he is making another offer. So we call it as counter offer. The other party to whom the offer is made, if he makes the offer or if he changes the original offer, then we call it as counter offer. Okay, and here original offer is not accepted by the offeree because he is making some changes to the original offer. So first offer gets lapses. Okay, first offer gets lapses, and this counter offer may not be accepted by the offerer. Hope this is clear. We have one case law. You will understand that clearly if we discuss that. Hyde versus Wrench. Okay, that is one case law. Here what happened, I'll read that. You please check that. One person offered to sell his farm for 1,000 pounds. So A is one person, he offered to somebody X, okay, to sell his farm for 1,000 pounds. X said he would give 950 pounds. What X replied? Actually, he replied that actually whenever A offers, X has to accept it. If he does not want to accept, then he will just say that I don't want to accept. He cannot make any changes to the original offer. But what X is doing here? X is saying that I will give you 950 pounds. Okay, whenever X changes the original offer, 1,000 pounds is the original offer. He is changing it to 950 pounds. Then that time we can say that X is making a counter offer. He is not accepting. He is making a counter offer. So whenever he makes the counter offer, original offer will come to an end. Okay, and A refused. Offerer refused. I don't want to sell it for 950. He refused. And X then said, okay, X, then what he said that he would give 1,000 pounds. Okay, he said that I will give you 1,000 pounds and you can sell your farm. But already whenever X makes a counter offer, original offer came to an end. Now A, offerer, need not to sell. Okay, he can decline first offer. So A declined because first offer was not accepted by the offeree and he made a counter offer. And later he accepted the first offer. Actually, whenever A offered to sell for 1,000 pounds, X has to accept it. He did not accept. He made a counter offer and A refused it. Then X again is saying that okay, I will purchase for 1,000 pounds. So here first offer already came to an end and A need not to keep up his promise. Okay, so because that first offer already lapsed. Hope this is clear. This is known as counter offer. Okay, so actually here X filed a case on A and judgment came in favor of A because first offer came to an end, original offer came to an end because of counter offer, and A need not to sell his farm for 1,000 pounds to X because whenever he made first offer, X did not accept it. He made a counter offer for that. That is why first offer came to an end and later on X said that okay, I will purchase it for 1000 pounds, but A need not to sell it. Okay, hope this is clear. Let us go to next discussion. Cross offers. What is cross offer? Actually, in offer there will be two parties. One party is known as offerer, the other party is known as offeree. Whoever makes the offer is known as offerer. To whom the offer is made, he is known as offeree. So here cross offers means both the parties are making same offer to each other. Okay, identical offers are made to each other, and they don't know that both are making the same offer to each other. So in ignorance of each other's offer, they are making identical offers here. Such offers are known as cross offers. So these cross offers cannot become offers. Okay, they shall not constitute as acceptance of one's offer by other. So even both are making same offers, other party can't accept it. Okay, so those are not treated as valid acceptance and valid offers. Let us see one example here. D is one person. He wrote to P on 28th November 1971 that D is offering to sell 800 tons of iron at 6,900 per ton. So D wanted to sell to P and he is offering to sell 800 tons of iron at 6,900 per ton. On the same day, what P is doing? He actually does not know about D offer. On the same day, he is also writing. He also wrote to D, and he is offering that I want to buy 800 tons of iron for 6,900 per ton. Same offer. If you observe, same lines are there. Okay, so both wanted to do same thing, but in ignorance of each other's offer, they made the offer on the same day. Okay, the two letters crossed in the post, and neither of them knew anything about the offer to the other. So they both did not know about each other's offer, and in ignorance of those offers, they made the offer. And P contended that there was a good contract. So what P said that okay, it is a good contract, both offer to each other, but it is not a correct offer because both made the offers to each other without knowing about each other's offer. Okay, so these are known as cross offers. Simultaneous offers are known as cross offers. Okay, hope this is clear for everyone. So like the video, share the video and subscribe the channel. Thank you.